So, counsel, we've talked a lot about burden, and I'd like to get a definition. So Justice Sotomayor's questions, I think, track what the Fourth Circuit said, which is that compulsion is required. That's not your position, that compulsion is too far, right? So can you precisely define for me what it means to have a burden?
Yes, I think there's three main ways this court has reviewed that. Under Yoder, it would be, is there substantial interference with the parent's ability to direct the religious upbringing of their children? We think we've shown that here. Under cases like Sherbert that have continued through to Fulton, it's, are the parents being pressured to abandon or modify their religious beliefs in order to access a public benefit, like public education? And then I think we also have what I think Justice Gorsuch may have been suggesting, just if there's straight up discrimination where some religious students are opted out and others aren't, then that itself would also be a burden. And I think we satisfy any one of those tests.
Okay, I have questions for you about those tests, but I'm going to bracket them to just follow up on the burden question. Substantial interference from Yoder. So would you say you could root it in that because it's rooted in the case? Is it somehow rooted in the definition of prohibit in the First Amendment? Because it seems to me that, the questions that you're getting are about line drawing. I mean, Justice Kagan was making this point. And one place where some of that line drawing might happen is in the definition of burden. So I think the definition of burden is important, and really that's the main thing that's before us. The question of whether you get an opt-out really goes to the Smith analysis or strict scrutiny under Yoder. We don't even have to decide that, right? We don't have to decide whether you get the opt-out. We just have to decide if the Fourth Circuit accurately defined what a burden is.
I mean, the court doesn't have to, it's true. I think there are multiple reasons why this court should.
I know you want us to, but we don't have to.
Correct.
And really what we have to do is nail down what it means to burden the right?
That's correct.
Okay, so unreasonable interference, and you would root that primarily in Yoder for that strain of the doctrine.
Correct.
Okay. Now, what kind of a claim are you bringing? Are you bringing a hybrid rights claim for purposes of Yoder? Are you kind of bringing all of them, like a straight-up free exercise claim, a Smith claim? I mean, it's a little bit hard to pin down.
Yeah, I think we're bringing all of them. We think in Smith, the court said that Yoder fell outside of its rule. Excuse me. And so we think that that's a separate track. And whatever the court meant by hybrid rights or other rights that were at issue in Yoder, we have those same here. However you define that, this is almost exactly the same situation where parents are concerned about what their children are being taught in the highly coercive environment of the public schools. And here we have even more egregiously curriculum designed. The board said when you select these books, we want you to select books that will disrupt cisnormativity, disrupt heteronormativity. And so we think that whatever Smith meant by hybrid rights that may have been at issue in Yoder, we meet that definition.
Do we have to embrace the hybrid rights theory in order to analyze your claim or your definition of burden for purposes of Yoder? Do we have to say Yoder is about hybrid rights and this is why you satisfy?
I don't think so, Your Honor. This court, as recently as in Espinoza, recognized Yoder as a case being about the free exercise right of parents. The questions presented in Yoder were all about free exercise. And so I don't think that any side statements that were made in Smith have to govern how this court treats that rule here.
Okay, and now let me ask you about the burden in this case. So there's been a lot of talk about exposure. The Fourth Circuit said this is just about exposure. You've pointed out, that in cases like, intersection allies, there's actually in the book, it presents a worldview, right?
And it says, let's disrupt the norms, that book.
Let's disrupt the norms, and many of the books, it's not just pictures, it's actually the text it's talking about there are not just two genders, embracing, non-binary and pronouns, et cetera. So that's exposure, though, to those ideas. It's not just exposure to the pictures of, the two men getting married. It's exposure to the ideas.
That's correct.
But to clarify, what are your clients objecting to? Are they objecting only to exposure, or are they objecting to what they're calling indoctrination?
If by exposure you mean having the books read to them, they do object to that. They're not objecting to the books being on the shelf or available in the library without a teacher requiring them to read it or reading it to them.
So you would not be making the same claim based on your client's religious beliefs if they were just on the shelves or just in the library?
Correct.
Could another parent bring that claim?
I suppose they could, but then you would, I mean, again, we don't see these kinds of claims happening, but they would almost certainly lose because strict scrutiny would easily be satisfied if every student were allowed to say, I want this book or not that book. I mean, no student has the right to tell the school which books to choose or what curriculum to teach or what other students will have to learn. And so we think that those would easily fail under strict scrutiny.
Okay, so it's not about exposure, it's not about books on the shelf, it's not about books in the library, it's about actually reading the books with the text that communicates the ideas that are contrary to your client's sincerely held religious beliefs.
Right, their beliefs, they follow, for example, the papal exhortation under Familiar Consortio that they shouldn't expose their children during their innocent years to instruction on sex that's disconnected or disassociated from moral principles. And so that's what they're, and the Mahmoud family, they also have an objection to any kind of discussion for young children outside of their family circle, as do many families, as the courts noted.
Okay, and so I want to talk about the public benefit analysis. So the government frames this in terms of public education as a public benefit, and your friends on the other side do too. And I'm just trying to figure out if that's the right way to think about this, because in Maryland, you're compelled to send your children to public schools. And it's a misdemeanor if you don't, and you're fined if you don't. And it's true that the statute gives you an exemption to that compulsion if you choose homeschooling or private school. And what is it, like thorough and comparable instruction. But this isn't like a public benefit like we apply for, rubber tires for our playground, or, we apply for a license to engage in some kind of activity. There's actually a compulsion here. So is public benefit the right way to think about this?
Well, I think if the court does think about it in that context, it's a much more valuable benefit than just getting access to rubber tires or some of the other things this court has found burdened religion. And so, but also I think the coercive element is adequate for this court to reach a conclusion in favor of my client.
Well, which way do you think it fits better? I mean, you're compelled to send your child to public school and pay a fine unless you take advantage of an exemption. So it's just hard for me to see how it's a public benefit in the same way that some of our cases have talked about public benefits. So which model? I mean, I understand you don't want to disclaim public benefit, but which way do you think it fits?
Well, I think certainly the Barnett example is a very good example of where you're actually compelling children to do things that are against their beliefs, and I think that would be that's a very fitting model for this case.
Okay, thank you.